stonewalling, and suffering. This is Law and Society. Please subscribe, and let's talk today about the illegal removal of Abrego Garcia and hundreds of others like Andry Romero, and how callously the government is dealing with these cases. So Kyle Cheney of Politico reported that the Trump administration says it has no legal obligation to help Abrego Garcia get to the United States, and details of its arrangement with El Salvador to house U.S. deportees are classified. So I went into these documents, and so first of all, the government is complying with Judge Sinis's order to give her a daily report of what they are doing, what they have done, where he is, and what they are doing to facilitate Abrego Garcia's return to the United States. Now, as I said in the previous episode about this, the first one to reply to the daily briefing was somebody who managed diplomatic affairs for the Western Hemisphere for the Department of State, which gave me the thought that Donald Trump is trying to remove Abrego Garcia as far as he can by now bringing in the fact that he is being housed in a foreign prison. Well, he's being housed in the foreign prison per contract of the U.S. government and El Salvador, which now the government says is classified, and we'll read about that. And so essentially saying that the court doesn't have the power or authority to go beyond their domestic jurisdiction. What the truth is that the jurisdiction attaches to the person who was illegally removed and sent to El Salvador against an immigration order. So we're going to read a little bit, we're going to read the daily update first, and then I'm going to read you the government's reply to additional relief that Abrego Garcia's lawyers asked for. Here we go with the second day's update. It was given by somebody by the name of Evan Katz, who is the assistant director for the removal division within the Department of Homeland Security. So at least this time, and ICE, and so somebody from that department is writing because they are the ones who have direct knowledge of this. So Mr. Katz writes, during the proceedings in 2019, an immigration judge upheld DHS's decision not to grant bond, finding that DHS determination that he was a member of MS-13 was trustworthy and supported by other evidence, and noted that Abrego Garcia failed to present evidence to rebut that assertion. The Board of Immigration Appeals upheld the finding when Abrego Garcia appealed. On March 15, 2025, Abrego Garcia, a native and citizen of El Salvador, was removed to El Salvador pursuant to Title 8 of the U.S. Code. Now remember this. In the previous briefing, they said that Abrego Garcia was being held pursuant to the domestic sovereign authority of El Salvador. Now he's being held pursuant to American law. So if he is now receiving reprieve under Title 8, was ordered to be removed under Title 8 of the U.S. Code, then U.S. Code is the one that has jurisdiction over him and is doing this. It's not domestic El Salvadorian authority. The only reason why El Salvador comes into the picture is because Donald Trump contracted with El Salvador to house detainees, no questions asked. Then he goes on to say, although Abrego Garcia has an order of removal issued by an immigration judge, I understand that he should not have been removed to El Salvador because the immigration judge had also granted Abrego Garcia withholding of removal to El Salvador. However, I also understand that Garcia is no longer eligible for withholding of removal because of his membership in MS-13, which has now been designated foreign terrorist organization. So all of this narrative that he is giving, it gives us information of how the government is thinking about removing Abrego Garcia's legal protection that was put on by the immigration judge and then affirmed by the Supreme Court when they said you have to facilitate his return to the United States. They are just litigating that in their statement that they're making. There's no sort of evidentiary hearing about whether he is MS-13 or any of that. There's no due process being given. This is the government's narrative with Abrego Garcia not having the opportunity to face his accuser and stand up for his rights. Then he goes on to say that I have reviewed the declaration by Mr. Kozak the previous days, which was filed on the 12th. It is my understanding that defendants have no updates for the court beyond that provided yesterday. So, gave us some information about what the government is thinking. I wanted to read that to you because they are talking about him being in sort of a gray area since he's a citizen of El Salvador, and then talking about the immigration judge's stay to not allow him to not deporting him to El Salvador, which is exactly what they did. And the government owned up to it, fessed up that it was an error. But still, now you will see when I read this other reply that the government gave, that their argument is that Abrego Garcia essentially is in a place where the district court cannot reach, and the Supreme Court has said clearly that the power rests in the executive when it comes to foreign affairs. Mind you, now they're shifting gear to foreign affairs and the core power. No one's denying the core power of Donald Trump. Even as the executive officer who would have, enforced the due process of law had it been carried out legally in the way that it's supposed to happen. No one is contesting that. But you see the attitude of the government and Donald Trump's administration that has this lofty idea of where the presidency is and how the lower court should mind itself when it is administering this case. So in the separate filing, and I'll put in links to these filings in the description box of this video. I'm reading this to you because I think it's important for everybody to understand what the thinking and the logic of the government is in denying not just Abrego Garcia, but all of these hundreds of people that they have now illegally shipped to El Salvador. I don't know if there are other countries, but so far as we know, El Salvador's terrorist prison. So in that reply, the government says the relief sought by plaintiffs is inconsistent with the Supreme Court's instructions requiring this court to respect President's Article 2 authority to manage foreign policy. The court should therefore reject the plaintiff's request. for further intrusive supervision of the executive's facilitation process beyond the daily status reports already ordered. The Supreme Court explained that on remand, any new order must clarify the scope of the term effectuate in a manner that did not exceed the district court's authority. So here you can see Donald Trump's own disdain for the lower courts. He will only take the Supreme Court's command. And you see him, his lawyers, they have become his lawyers, despite the fact that the DOJ is a law firm of the United States and not a person, but now it is working for a person. The court instructed that any directive must give due regard for the deference owed to the executive branch in the conduct of foreign affairs. And it made clear that any directive should concern Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. In response, this court amended its prior order that evening to direct the defendants to take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible. Defendants understand facilitate, and I'm reading this to you, it's nauseating because it is irritating that they are now going into how it's being interpreted and what the word means and how you can go beyond its constitutional meaning. Defendants understand facilitate to mean that term has long meant in the immigration context, namely actions allowing an alien to enter the United States. Taking all available steps to facilitate the return of Abrego Garcia is thus best read as taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. So it is saying that the district court's power is to only tell domestically what the government can do in order to ensure that that the person is brought back here. You cannot, it's talking about only the domestic obstacles that impedes the ability. Indeed, no other reading of facilitate is tenable or constitutional here. This reading follows directly the Supreme Court's order, holding any directive must give due regard to the executive branch's exclusive authorities over foreign affairs. You see how it keeps on saying exclusive authority of foreign affairs? Like if you repeat it enough times, that it will become real. But the truth of the matter is that it is not in the exclusive purview of foreign powers, because we are talking about an illegal removal of a resident of the United States in the District of Maryland who was removed without due process of law, who is now in El Salvador because the government contracted with El Salvador to house detainees coming from the United States without any questions asked. So, it's to me, it's kind of like it's flouting the Supreme Court's order by sort of denigrating the district court by saying, oh no, you're going beyond your power. This reading follows, on the flip side, reading facilitate as requiring something more than domestic measures would not only flout the Supreme Court's order, but also violate the separation of powers. The federal courts have no authority to direct the executive branch to conduct foreign relations in a particular way or engage with a foreign sovereign in any given manner. This is the exclusive power of the president as the sole organ of the federal government in the field of international relations. Okay, all that is said and done doesn't get to the answer of why Abrego Garcia is not being brought back. And you see Donald Trump pushing it towards it becoming a foreign diplomatic classified issue, instead of it being an illegal removal, facilitation of return for due process of law, as the Supreme Court commanded. The Supreme Court has to make a ruling in order for Donald Trump to comply with it. That's what's becoming clear over here. So, such power is conclusive and preclusive and beyond the reach of federal courts' equitable authority. So that's going and relying on the immunity decision, saying that it's conclusive and preclusive, talking about the foreign affairs power. And yes, sure, foreign affairs, it is conclusive and preclusive, but this is not a foreign affairs issue. Donald Trump is, after the fact, making this a foreign affairs issue. Plaintiffs asked for additional relief. They asked to make demands to the El Salvador government, dispatch personnel onto the soil of an independent sovereign nation, send an aircraft into the airspace of a foreign nation. Well, they are suggesting ways to facilitate the return of Abrego Garcia. The government says all those requested orders involve interactions with foreign sovereign and potential violations of that sovereignty. Well, we're talking about a contract here. We're not talking about sovereignty of another country. We're talking about a contract under which this person is being illegally held without due process of law, over whom the District of Maryland has constructive general jurisdiction, because Abrego Garcia is a resident of the District of Maryland. But as explained, a federal court cannot compel the executive branch to engage in any mandated act of diplomacy or incursion upon the sovereignty of any nation. We're not talking about the sovereignty of a nation. Again, although defendants were not prepared to share the information with the court within hours of its order, defendants responded to the first of the court's questions yesterday evening and confirmed Abrego Garcia is alive and secure in custody of El Salvador at the Terrorism Confinement Center. Defendants will continue to share updates as appropriate. Any further intrusion into this sensitive process, any directive from the court to take action against the nation of El Salvador, that's not what the court is doing. The court is not even talking about the foreign relations part of it. It's talking about facilitating the return of Abrego Garcia, who is being held under contract, who was illegally detained, who was illegally removed from the United States to the very place where he was ordered not to be removed to. Then he goes on to say that it's exhausting, sorry, but I want to read this to you. It's important. The court should deny expedited discovery requests by plaintiffs. This discovery, including the presentation of live witnesses, would probe the executive's preliminary thinking on diplomatic efforts. What diplomatic efforts? And would go well beyond requiring the executive to reveal what it can about the status of this process. That request is particularly inappropriate given that such discovery could interfere with ongoing diplomatic discussions, particularly in the context of President Bukele's ongoing trip to the United States. The court hasn't asked for any of that information. The court has asked for the facilitation of the return of Abrego Garcia and what is being done to facilitate that and what is to be done. In addition, plaintiff's request for documents calls for immediate production of classified documents, as well as documents that defendants may elect to assert as subject to protections of attorney-client privilege and state secrets privilege. It would be inappropriate for this court to hastily order production of these sensitive documents, while the court ordered the production of those documents and to take care to seal the documents as necessary. So the government completely ignores that part of the order. The court should not issue the order to show cause. Plaintiffs began their motion with a quote from the president confirming his respect for the Supreme Court and intention to comply with its order. Defendants remain in compliance with the Supreme Court's order. based on the Supreme Court's order and respect for both the executive branch's authority over foreign affairs and the sovereignty of El Salvador, this court should take no further action in response to plaintiff's motion. So essentially saying, the due regard that the Supreme Court has said, you better watch yourself where you're going. You better watch yourself because you are going into foreign affairs now, which Judge Sinis is not doing at all. I've repeated that several times. So that's where we stand with the Abrego Garcia case. And if you are frustrated because I read this to you for 20 minutes, imagine what Abrego Garcia is going through in that prison. Now I'm going to turn to Andry Romero. And this came to my attention by a post posted by Stephanie Kennedy, who worked for Biden and Harris, and her post on Blue Sky that was supported by an NBC story. And I'll put all those links in the description box. I want you to understand Andry Romero's story, because we don't know where we are with him coming back and him being safe. And it is important to me, and it should be important to everybody, because how he's being treated, there could be many, many more like him who are vulnerable and sitting in that terrorist prison without due process of law. Stephanie Kennedy writes, his name is Andry Hernandez Romero. He's a young professional from Venezuela. He's a makeup artist. He's a gay man. Andry was a target for abuse in his homeland of Venezuela. He was viciously humiliated daily, the victim of discrimination for his sexuality. He was also being persecuted for his opposition to Venezuela's authoritarian government. So Andry came to America seeking asylum. Andry was detained after crossing the border at the legal point of entry. Originally, U.S. officials determined that Andry demonstrated a credible fear of persecution in his home country. But during the physical examination, officials turned their focus to Andry's tattoos. They are images of flowers, a butterfly, and a snake on one arm. Each of Andry's wrists featured a crown with the words Mom and Dad inked next to them in English. Andry adamantly denied any form of affiliation with any gang. But officials added a note to his file. Upon conducting a review of detainee Hernandez's tattoos, it was found that detainee Hernandez has a crown on each of his wrists. On each one of his wrists. The crown has been found to be an identifier for a Tren de Aragua gang member. Stephanie Kennedy continues, experts who study Tren de Aragua say the gang, unlike other criminal gangs, do not use tattoos as markers of membership. This is coming from NBC News. Not only does Tren de Aragua not use tattoos as a mark of gang affiliation, but Andry's crown tattoos symbolize Three Kings Day, a beloved Christian festival in which Venezuelan families celebrate the Epiphany, a Christian holiday, held annually in his hometown of Capacho. Andry performed as an actor at the festival, working as a costume designer and serving as a makeup artist. Trump ordered that Andry, along with nearly 300 others, be abducted and deported, flown far away and thrown into a sprawling prison filled with masked guards, multiple forms of torture, and never-ending pain, with absolutely no due process. Trump illegally sentenced Andry to life and death in prison. That prison in El Salvador's notorious CCOT, a massive terrorist confinement facility that it is, in fact, a torture chamber with a 40,000 person capacity. If left unchecked, Trump's regime's broad assault on due process and the right to seek asylum will not end with men like Andry, Kilmar, Abrego, Garcia, and countless of others. All who oppose the Trump regime must now live in abject fear based solely on Donald Trump's order. Any one of us can be abducted and deported, sentenced to relentless torture and death in a hellhole prison far away. The family fears for safety of Venezuelan makeup artists deported to El Salvador mega prison. That's where we stand with the story of Andry, who was illegally removed and sent to El Salvador without due process of law. So let's keep our voices up. Let's keep talking about these people. I will keep you apprised of what shenanigans the government comes up with every day. In the meantime, if you have the time, go and read the legal documents, go and read the Blue Sky posts that I provided to get a better understanding, because I haven't read you all of the information that was posted in these links. So with that said, call for the government to comply with the court's order. Judge Sinis is working under the order of the Supreme Court to facilitate the return of Abrego Garcia. Call for the return of Andry Romero and the hundreds of others who are currently suffering. Are there people who were sent who deserve to be sent there? Most likely, but a vast majority of them, vast majority of them are there, don't have criminal records. Andry sure as hell doesn't. The CBS did a 10-year analysis of his record, then there's no criminal record. So bring Andry home. Bring Abrego Garcia home. That should be our cry for them, because they can't voice their frustration, their pain, their suffering, and all we have is our voices to raise up on their behalf. So I hope you do. With that said, please like and subscribe, and I'll talk to you soon.